What happens when a courtroom turns into a battle between reality and pure delusion? Today's clip delivers exactly that. While digging through some wild court footage, I found a sovereign citizen who confidently argues that the defendant isn't actually a real person but nothing more than a piece of paperwork. And somehow it gets even crazier because he claims he would have turned himself in already if the jail accepted documents instead of human beings. The judge immediately realizes where this nonsense is heading and wastes no time shutting the entire argument down before the courtroom spirals any further. Trust me, this is one of those unbelievable exchanges that keeps getting more absurd every second, so stay tuned because you need to see how this disaster plays out.
Jesus Christ is King.
All right, cause number 2312933 and 2312934.
Aren't you going to take a seat?
No, I'd rather stand.
Well, it's your hearing, sir.
Is it okay if I stand? Is there something wrong?
Why do you have to stand so close to him?
The sign there that says no standing.
Oh, well, okay. I just know I was subject to those rules. I didn't agree to it. Anyway.
Okay, so there's a bench warrant.
You know what? I'm just going to take the seat.
Thank you.
Right here. That makes us a little more comfortable.
Is it uncomfortable if I stand up, Your Honor?
Well, depends on how you're going to act or behave today.
I'll have a seat.
Okay, so you failed to appear for court multiple times in this case.
Now, Your Honor, just for the record, the named defendant is actual property, a registered trade name.
Oh, here we go.
And the case has also been certified as a fraud. I have court certified documents to prove that. That should be on the record. And that's the reason why it was certified to be a fraud, because the plaintiff is a foreign-owned private corporation, of which I have no contract with, and neither does the registered trade name. And the registered trade name has been used without authorization and permission, and is an act of identity theft. And that's probably one of the reasons also why the state has acquiesced that both cases are a fraud.
If the court actually believed your claim that these charges were some kind of fraud, then this case would have been thrown out long before today and you would not be standing here in front of a judge answering for any of it. But that never happened because the reality is much simpler than the argument you're trying to make. You ended up back in this courtroom because you chose not to turn yourself in on one of the charges, and that decision brought the entire situation right back onto the court's radar. At this point, the judge has no reason to entertain the distractions any further, and the process has to continue forward with the failure addressed and a new court date scheduled so the remaining charges can finally be dealt with properly.
I just may add one more piece of information. I am a foreign sovereign with respect to the privately owned foreign corporation known as the state of Washington.
Okay, so on the 9304, I am going to quash that one. He was in RALJ appeal status, and so I'm going to quash that one. But I do want to hear from the state on the 303 matter.
Yes, on the 303 matter, Mr. Haywood was sentenced to serve 4 days in jail. He failed to report to the jail on June 29, 2023, and we're asking him to be taken into custody to serve that time.
No objection, Your Honor. I actually contacted the jail to make special arrangements to deliver the defendant with the special arrangements to not damage the paper, and the jail refused. So I attempted to deliver the defendant, and objection, the state has no standing as they are representing a privately owned foreign corporation, and the prosecutor is not licensed to practice law in this country.
Okay, so I think it's the 303 that he was convicted and ordered to do jail, and you believe that he didn't comply with jail because there's a docket entry that said defendant complied with jail. Maybe that was an error.
That was probably my attempt to deliver the defendant to the jail, but they refused.
There isn't a single jail in the country that's going to process paper people into custody, because in the real world, that's just not how any of this works. If anything, the only paper that moves through those facilities is the paperwork that tracks actual cases, not imaginary legal theories, and this is where you often see these kinds of arguments come up in sovereign citizen-style reasoning, where legal definitions get stretched into something completely detached from how the system actually operates. The issue is, instead of improving their position, these claims usually do the opposite. They create more confusion in court and end up making the legal situation even more complicated than it already was.
I understand, and we relooked that he had not, as was the state's understanding, he had not served the jail time.
And just to clarify, the defendant only exists on paper, just as the plaintiff only exists on paper. The jail refused the paper, and here we are today. And the state still hasn't proven standing yet, by the way, as well.
So, Mr. Haywood, it doesn't look like you did the sentence on the 303 matter. And so I am going to quash the warrant. However, I am going to have you serve that time.
Okay, well, I'll deliver the paperwork to the jail. That's fine. I tried to once before, but they refused it. And just to clarify, I'm not the defendant. There is nothing on there, nor is there any testimony from anybody as firsthand witnesses under penalty of perjury that I am the defendant. And I've uploaded plenty of documentation to prove I'm not the actual defendant. That is a registered trade name, matter of public record, and registered with the state. So if you want me to serve some jail time, then we're going to need to change who the defendant is, because I'm not the defendant.
All right. So can you upload a new commitment?
Yes, Your Honor.
And the reason they couldn't put my name on there as a defendant is because I'm a foreign sovereign with respect to the corporate entity known as the state of Washington, of which I have no contract with.
Wow, the land of make-believe.
Okay. So with respect to the 304 matter, which is still pending, what's your position on the warrant, Ms. Fredenberg?
The state was going to ask for that warrant to be served.
Objection to jurisdiction. The state has never proven any jurisdiction and has no jurisdiction or standing. So any requests or statements from any representative from the state are a nullity and a fraud. And the jurisdiction is challenged. It must be established on the record. And it hasn't been, and it still isn't. You can do it now if you like, if you can.
Okay. So, Mr. Haywood, you failed to appear many times in both of these matters, had many warrants quashed. And to be perfectly honest, I'm not confident that you're going to come back to court given the history here of failing to appear.
I will agree to come back to court on behalf of the defendant.
You can't proceed in that manner because you are not a licensed attorney, and the court does not allow unqualified individuals to represent other people in legal proceedings. So at this stage, the situation is actually very straightforward. You either choose to represent yourself and speak on your own behalf in this courtroom, or you retain a qualified, licensed attorney who is permitted to handle the case for you. Anything outside of those two options is not recognized by the court and cannot move forward in these proceedings.
The appearance fiasco was simply because the communication between the acting prosecutor at the time and myself. I have plenty of emails. So in one case, he said he was just going to reschedule with the judge. I told him, reschedule whenever you want. I'll go ahead and be there, and I'll bring the defendant with me. And next thing you know, there was a warrant for a failure to appear. So there's been plenty of fun and games with the acting prosecutor at the time. So it wasn't just a matter of not bringing the defendant to the court. The prosecutor was intentionally sabotaging the scheduling process.
Well, the prosecutor doesn't handle scheduling, the court does. So the court ordered you to be here and then you weren't. So.
Objection, the court ordered the defendant to be here. I am simply bringing the defendant to the court to help try to solve the problem. The fact that the registered trade name remains as a named defendant is an act of identity theft and fraud, and that's probably why the state has acquiesced that the case is a fraud. I have the documentation here with me today in case if they decided not to upload it to the court record.
Well, you had your day in court on the 303 matter. You had a trial. You represented yourself or the defendant, whichever way you want to say it, but you represented the defendant yourself, and you were convicted, and you were ordered to serve 4 days in jail. You didn't do that. And so
The defendant was ordered to serve 4 days in jail, and I attempted to deliver the defendant to the jail, but the jail refused.
okay, well, I'm going to make sure that they don't, because I've done a new commitment for you today so that they won't refuse for the defendant to serve that time. I'm going to serve the warrant, and so we need a pretrial date, Madam Clerk.
There's no jurisdiction yet been proven or standing. Are we going to continue? That would be an act of fraud and treason.
Your Honor.
That's a felony. That's an arrestable offense.
I put both of them in one of our.
Well, we don't need anything on the 303. He's just gonna serve a sentence.
Okay.
We just need the 304 and
Yes, I
I
have
see
the
that.
defendant here with me today. You can take him to the jail if you like.
Thank you, but that's not something the court is entertaining at this point. The judge has already issued the necessary directive, and law enforcement is now carrying it out. At this stage, neither agreement nor debate changes the outcome. Those decisions have already been made on the record. The proceedings are complete on that issue, and the focus has shifted to enforcement of the order as instructed by the court.
So your next court date is going to be September 13th. We probably need to change that since I'm taking him into custody. So do we have anything in August?
Excuse me, Your Honor. Are you testifying that I am the defendant under penalties of perjury?
I'm not testifying anything.
Good. And here's the defendant right here.
All right.
Your Honor, we can do August 24th at 10:30.
All right, I can change that.
Thank you, Your Honor.
So August 24th at 10:30 in the morning will be your next court date.
I will be here with the defendant, no problem.
You're going to serve those 4 days and then you'll be released and nothing more will happen on that 303 case. You'll be done. And then this case will be heard August 24th at 10:30 in the morning. If you change your mind about representing yourself, then you can ask for help if you want it. If you don't want help, we don't have to have it. So we'll see you in August. I'm going to have you take a seat right over there.
I won't be here for the defendant August 24th. Would you like me to deliver the defendant to the jail?
I would like you to sit over there
Is there any
with
standing
the
or
defendant.
jurisdiction chosen, proven here yet?
Please go take a seat.
Okay, so let the record reflect no jurisdiction has been proven.
Hold on for a moment, because the judge is about to make it very clear exactly how much authority the court has in this situation. There's no confusion, no gray area, and no room left for debate about how things are going to proceed. The message here is direct, the rules are set, and the courtroom is moving forward under that authority without hesitation.
And neither has the identity of the defendant definitively been established.
Okay, please go take a seat. Sonia Sesko, customer 23102-402. Mr. Haywood, sit down.
Am I obligated to follow these rules?
You are going to sit down right now.
Do you have any jurisdiction? I don't believe you have any jurisdiction's been proven yet.
Please sit down.
Are you threatening me with violence?
I'm asking you to sit down.
You don't have authority over the defendant. You have no authority.
What are you doing?
Mr. Haywood?
You're escaping?
I got things to do.
No, sir.
What?
You are in custody right now. If you leave the courtroom, it's a felony escape.
That's a felony to put me in custody because you have no authority or jurisdiction or standing. You got some proof of
Okay,
that?
well, we are all being recorded, so if you leave this courtroom, it'll be a felony escape charge. Your choice.
Okay, well then, I guess in the best interest of peace, in regards to your violence, I will go ahead and relax for a minute, but let's get with it. I got things to do.
At this point, it would be in your own interest not to escalate things further or risk compounding the situation with additional charges. The instruction is simple: take a seat and comply with the court's direction immediately. Consider this a brief procedural hold while deputies complete what they've already been assigned to do. Whether you agree with the outcome or not, the process is already in motion and will continue as ordered. The best course right now is to stay calm, follow instructions, and avoid turning an already serious courtroom moment into something even more difficult to manage.
Got it?
What was that just thrown?
Car keys.
Do you know that person?
Yeah, they're my voice.
Okay. All right. So thank you. Mr. Haywood has been very disruptive. He tried to leave the courtroom once he was placed in custody. So just FYI, be careful with him.
So, give me a break. Can I just see just need to see it, thank you. Can I see who's being put into custody, please? I just need to see the name. I just need to see the name of the person. Okay, that's not me, that's the problem here.
At this point, the situation has moved beyond argument or interpretation, and it's simply about procedure taking its course. The court has already made its position clear, And what follows is the practical enforcement of that decision. No amount of rhetoric or alternative legal theories changes the fact that the proceedings are active and being carried out as ordered. From here, it's a matter of the established process continuing forward step by step, with law enforcement ensuring the court's directives are followed and the case moves to its next stage.
Our Sanborn's matter, we're here today on.
That's not me. The name is saying it, but that's my registered trade name. I got all that documentation right here.
Okay, good. We're gonna take care of it.
Okay. Yeah. Well, this is the defendant technically.
If you want that, I can go with you, put everything private.
1 second. Well, that's taken care of.
We can think that we can get the right name.
Did she file a notice of appearance?
I will make sure that she does, Your Honor.
Okay. Yeah, sorry, I haven't had enough coffee yet today. So yeah, no, you've got Ms. Bradshaw, so that's fine. You don't need to do those forms. But she does need to file a notice.
Alright everyone, that wraps up the video. Seeing sovereign citizen arguments collide with real courtroom procedure is always one of those moments where theory and reality completely diverge, and the outcome ends up being decided by the system they're actively challenging. At the end of the day, the court process continues on its own terms regardless of how it's interpreted or argued. If you found this breakdown interesting, feel free to like the video, share your thoughts in the comments, and subscribe so you don't miss what's coming next.